Here's an evidence hypothetical that gives us a very clear look at where evidence and criminal procedure touch one another. I think remedies is the most important subject on the exam, but plenty of people think evidence is just about as important, or maybe even more so. And this question is a good example of why they have that theory. This is a subtle, difficult question, and just by glancing at it superficially, we can see that it's an evidence problem with 5 items of evidence. That means that we're going to be in quite a bit of a hurry on an essay. This fact pattern also could be a model for a multi-state bar exam question stem, and the questions presented in the 5 items of evidence easily could be turned into multi-state questions. This question may be the most practical, and likely the most interesting, of all of the evidence hypotheticals that we're going to look at together. Take a look at the very bottom, at the call of the question. All it asks are, were the items of evidence properly admitted? Discuss. We glance up and see that there are 5 items of evidence, and so, intellectually, we've organized our answer to this question already. We've got 5 items of evidence. We'll talk about logical relevance at the beginning of each one, then we will figure out as many of the objections as we can, and ultimately, we'll reach a conclusion about whether or not the item of evidence was properly admitted. Fair enough. Our approach is clear, and as we go to the top of the pattern, we notice that this is really a very simple and straightforward situation. We've got an armed robbery of a pharmacy, and the bad guy takes a bottle of morphine, a controlled drug, and the bad guy leaves with the morphine. Later on, D is arrested for the crime, lawfully, several days later. He's charged with armed robbery. He goes to jury trial. His defense is that he was at home when the robbery occurred. So he's saying, I didn't do it, I wasn't even there. Then, at the trial, we learn about the prosecution's case in chief. And here we get the 5 items of evidence. Well, we know what the job is. We're supposed to figure out the objections and figure out whether or not each item of evidence was properly admitted. So, let's just glance through quickly and see what we can determine. Item 1 is the testimony of Tom, a close acquaintance of D. He is testifying as to prior specific bad acts. Tom says D has possessed and consumed morphine many times during the 2 years prior to the robbery. He's seen it. So, initially, we react to just say, well, this is improper character evidence. However, since it's a criminal case, and since mimic and habit evidence both seem to be ways that this might turn out to be actually quite probative, perhaps we'll be able to let it in. Then we go to item 2. Here we've got a properly authenticated letter, so we don't need to worry about the best evidence rule or any of the other traditional objections relating to documents. It's dated 10 days before the robbery, D to clergyman, and it's basically a confession in advance of the crime. This is a hearsay problem and a privilege issue. We turn to item 3, and here we've got Officer Alert testifying that D runs upon capture and then is recaptured. Here, the only possible objection would be hearsay. It's likely that this will not be sustained. We move on to item 4. Here we've got Officer Alert in court seeking to testify as to a prior identification of the defendant at a lineup by a witness who is now deceased. And so the question is, can Officer Alert testify? This is clearly a hearsay issue, but when we look more carefully, we see that this really is a criminal procedure issue with regard to the Sixth Amendment right to confront. Finally, we turn to item 5, and we encounter more criminal procedure issues as we find that this is the testimony of Lockup, who is a fellow inmate, and he testifies that D stated to him that he was in the pharmacy, but he did not commit the robbery. Well, this looks like an admission, and it would also be hearsay, and it also could be a Miranda violation, and we need to consider criminal procedure objections. So turn the page for a minute and take a look at my outline of issues here. Again, there's nothing terribly innovative going on here. What I'm aiming at is accuracy and thoroughness. We've got time pressures if we're facing these issues on an essay, and so I want to be as well organized and thorough as possible under the time pressure. what I've done here is pretty much identical to what I've done for all of these evidence hypotheticals. I've assigned a Roman numeral to each item of evidence, and then I've explained logical relevance up front, and then gone into the various objections. So let's carefully review for a few minutes together the basic issues that are presented, and I'll try to show you how one would rationally resolve the questions presented in this hypothetical. So we begin by focusing our attention on Tom's testimony. Tom has testified that he's watched Dee possess and consume morphine many times in the 2 years before the robbery. This is relevant because it suggests that Tom had a motive to commit the robbery. The objection would be based on character evidence. Dee properly can object to Tom's testimony if the prosecutor tries to use it to show that Dee had a propensity to commit the charged crime. Tom's testimony is inadmissible to show that Dee's prior morphine use meant that he was likely to have robbed the pharmacy. But we turn to the mimic rule, and we see here that past crimes evidence may be admitted to show motive, identity, etc., pursuant to the mimic rule. As I just mentioned, Tom's testimony is relevant to prove Dee's motive. A drug addict has the motive to rob a pharmacy of drugs. Next, we turn to habit evidence. The prosecution may also be able to get this evidence in to show Dee's habit of morphine possession and use. To resolve the issue, it would be necessary to get a more specific idea of how often Tom saw Dee possess or use morphine. In order to be admissible habit evidence, the testimony must establish that the behavior is frequently repeated. So, ultimately, I would conclude that it would not be an abuse of judicial discretion to admit this evidence. It's true that Tom's testimony is highly prejudicial to Dee. The defendant's going to argue that the court abused its discretion in admitting the testimony because the testimony is more prejudicial than probative. The facts really are silent as to whether or not the judge issued a limiting instruction, but it's unlikely the court's decision will be overturned as a clear abuse of judicial discretion. Next, we turn to the letter from Dee to his clergyman. Dee wrote his clergyman 10 days before the crime and stated that he was suffering and was going to rob a pharmacy to get some morphine. The properly authenticated letter is relevant because it makes Dee's motive and intent absolutely clear. The first objection that Dee would raise is the clergy penitent privilege. Dee's letter obviously was written with the expectation that the clergyman would keep the contents confidential. Both Dee and the clergyman hold this privilege. No facts suggest Dee's letter was written for any reason other than as part of Dee's efforts to get spiritual help. Dee did not enlist the clergyman's help as a co-conspirator. As a result, it was error for the court to admit Dee's letter. The next objection Dee would raise would be hearsay. Dee's letter is an out-of-court statement. It's being offered in court to prove its contents. As such, it fits the traditional definition of hearsay. Under the federal rules, however, admissions like this are deemed non-hearsay. Other jurisdictions treat them as exceptions to the hearsay rule. The letter should have been excluded as privileged. The court erred in admitting this evidence. We now turn to Officer Alert's testimony about Dee's attempted escape. Officer Alert testified that Dee tried to escape during his arrest 5 days after the robbery. The testimony is relevant because it suggests Dee was conscious of his guilt and wanted to avoid prosecution. Dee's only objection is to claim that this is hearsay. Dee will argue that his flight was the same thing as an out-of-court statement. The problem is, it's not going to be a successful argument. The argument is basically without merit. That's one thing that makes this part of the question fairly difficult. But the problem here is that Dee's escape attempt is non-assertive conduct, and therefore it is non-hearsay. It isn't like symbolic speech. The court properly admitted this part of Officer Alert's testimony. Next, we turn our attention to Officer Alert's testimony about the lineup identification by the witness. Officer Alert went on to testify about Witt's lineup identification of D as the person who committed the robbery. The testimony is highly relevant because it directly connects D to the crime that he is charged with. D's first objection is hearsay. Officer Alert is quoting for its truth Witt's out-of-court statement. Number 3 is the man who did it, I'm positive. Thus, the testimony fits the hearsay definition. The prosecution's problem is that Witt is an eyewitness who is now deceased. That fact makes Officer Alert's testimony inadmissible hearsay. Had Witt been available and subject to cross-examination, Officer Alert's testimony would have been deemed non-hearsay under the federal rules. The court erred in admitting this part of Officer Alert's testimony. D's second argument has to do with the Sixth Amendment right to confront. D will also contend that his right to confront and cross-examine hostile witnesses would be violated by allowing the policeman to quote a dead eyewitness. There is no concrete assurance that Officer Alert's testimony is reliable. The testimony is extremely prejudicial. The court erred in ignoring this second compelling reason to disallow this testimony. Finally, we turn to Lockups Testimony about D's statement in jail. Lockup testified that D admitted being at the pharmacy when it was robbed, but denied committing the robbery. Since D testified that he was at home when the crime happened, Lockup's testimony is relevant to impeach D. The first objection that D will make is hearsay. D will argue that his out-of-court statement is being offered for its truth and is inadmissible hearsay. But because his statement is an admission by a party, the federal rules would deem it to be non-hearsay, and other jurisdictions would treat the testimony as an admissible exception to the rule. The court properly overruled the hearsay objection. D's only hope of proving the judge erred would be based on criminal procedure law. If Lockup was acting as a police agent at the time D made this statement, D's Fifth Amendment right to remain silent and his Sixth Amendment right to counsel may have been violated. The facts are not specific enough to present a firm conclusion. If Lockup had been merely a passive listener, the statement is admissible. If Lockup was actively questioning D, their exchange would amount to a custodial interrogation, and the statement would be inadmissible. And that concludes a discussion of what I think you'll agree is a quite difficult and subtle evidence question based on criminal law and procedure.